Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content. Today may be the day I earn your subscription. For today's coverage, we are doing twice again, we are doing legal. Yes, we didn't have enough of the legal the first time, so now we have some legal the second time. He has produced a new video about the judge in the Rittenhouse case, entitled "What's the Deal with Rittenhouse Judge Schroeder?" Or, to do my best Jerry Seinfeld, which probably isn't that good, "What's the deal with Rittenhouse Judge Schroeder?" That's what we're doing. Okay. So we're going to listen to some thoughts about Judge Schroeder and see what he has to say. And I'm sure this analysis will be just as good as the last one. So as before, content warning. This episode of Uncivil Law may include images and sounds of legal. Okay, great.
If you were following the trial of Kyle Rittenhouse on social media, you might have come to the conclusion that Judge Schroeder was a hopelessly biased nutcase who was making up all the rules to help Kyle Rittenhouse. Was he?
If you were following the case, you might have come to the conclusion that he was coming up with rulings just to favor Rittenhouse? Really? What trial were you watching, man? I mean, the premise here is if you watch the case and you think that he was making rulings just overly favoring the defense just constantly by allowing in images that were manipulated by government that their own experts couldn't testify to how they were made, or FBI drone videos that were produced at the last possible minute and to which the defense didn't have a full resolution copy. That brought in too. Or in basically failing to rule on basically anything until the last possible moment, among other issues. So just, if you watch this trial, that's what you'd think? Okay. All right, fine.
Now, most of the situations that people are objecting to involve the application of the rules of evidence. In state court, the judge has broad discretion to make rulings on the admissibility of evidence and how to run their courtroom. This includes things like which witnesses are allowed to testify, what the lawyers are allowed to ask, what topics are off limits, and a whole bunch of other things. And there were a few incidents that stuck out. So let's talk about incident number 1, where Judge Schroeder ruled that the prosecution could not call the people that Kyle Rittenhouse shot and killed victims.
Yeah, so the logic here, as I'm sure legal will undoubtedly tell us, is that the term victim is prejudicial, right? Because we don't know if they're victims or not yet. Because victim implies that there's a bad person who victimized them. And we don't know if there's a bad person yet, right? That's kind of the whole point we're here. So the term victim becomes a bit of a loaded term. So this judge thought, out of an abundance of caution, we shouldn't use that term because the term implies there's a bad guy. And we don't know if there's a bad guy yet. All right, yeah, okay.
The defense attorneys argued that using the word victim could prejudice the jury against Rittenhouse. Judge Schroeder said the word victim is a loaded word. When the judge ruled in favor of the defendant,
What? He said that weird. He said that weird. It's a loaded word. His tone, the way he said it was just wrong. Hold on.
The jury against Rittenhouse. Judge Schroeder said the word victim is a loaded word. When the judge,
I think that emphasis is backwards. It doesn't sound right to my ear.
ruled in favor of the defendant, critics jumped to the conclusion that Judge Schroeder was showing inappropriate favoritism to Rittenhouse. Now, trial judges have lots of discretion. The Wisconsin rules of evidence mostly track the federal rules of evidence. Even if particular evidence isn't explicitly ruled out, judges have lots of leeway. Wisconsin Rule of Evidence 904.03, which is very similar to Federal Rule of Evidence 403, states, quote, although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence.
Yeah, so that's a good rule, and it's good. The same rule in the federal system, right? So you can have the idea that the evidence is strictly speaking relevant, but a judge can exclude it for a bunch of reasons. So we'll deal with that in a different order. Presentation of cumulative evidence. If we've already heard the same evidence from multiple different people, right, then we don't really need to bring in another person again to testify to the exact same thing. So what is unduly cumulative is a little bit in the eye of the beholder, but you don't want just person after person after person coming in just to give the exact same testimony. It's a little much, right? If it's a waste of time, right, it's technically irrelevant, but it deals with issues that are so tangential that it doesn't really help. Undue delay, technically relevant, but you're just stretching out the trial time. Confuses the issue. Technically irrelevant, but goes to issues not before the jury. So it can be excluded because it would mislead. And then the big one here is the first one. Substantially probative, if the probative value is substantially outweighed by unfair prejudice. So the evidence is technically relevant. It's technically irrelevant, and it might show something that would help the jury decide the issue. But the weight of the evidence is so bad, like it would lead the jury to a wrong conclusion. So the value, the juice isn't worth the squeeze. The value we're extracting from this testimony isn't worth it because it would unfairly prejudice. So, okay.
Or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. In other words, evidence might be minimally relevant, but if the risk of prejudice is too great, you shouldn't allow that evidence into the courtroom. And the way that a victim is used in a courtroom is different than what's used outside of the courthouse. Rittenhouse claimed that he was acting in self-defense. If he was right, the three men would not be considered victims in the legal sense of the word. They would be assailants who attacked Rittenhouse. People also suggested that Judge Schroeder was making up special rules just for Rittenhouse, but the judge's ruling was consistent with the way that he handles criminal trials. According to the Kenosha News, quote, that is Schroeder's standard practice in criminal cases and is not unique to this handling of the Rittenhouse case.
This does seem to be very true. This particular judge does seem to be a bit of a unique person, even within his own judicial zone, even among other trial judges. Other trial judges don't agree with him, but he has this hard and fast position on the issue. That's his judgment. So, and he's consistent on that position, is what everyone seemed to conclude. I think it's a correct position. It's probably a more conservative position in the sense of being safer for the defendant. So, okay.
Lawyers said these rulings were commonplace in their jurisdictions as well. Victims suggest guilt before it is proven, and prosecuting and convicting someone is hard, as well it should be. And of course, it's always okay to refer to these people by their names, which tactically can be even better because it humanizes them. In a court of law, a criminal defendant must be given his full due process rights. The whole object of a fair trial is not to prejudge the defendant. That means judges should be skeptical of evidence that a jury could use to infer someone's guilt if that evidence is not truly probative of what happened. And that brings us to the second incident where Judge Schroeder ruled that the three men who were shot could be referred to as rioters, looters, and arsonists. Well, specifically what Judge Schroeder said was, let the evidence show what the evidence shows, that any or one of these people were engaged in arson, rioting, or looting, then I'm not going to tell the defense they can't call them that. Prosecutor Thomas Binger said that this was a double standard. Quote, I think it's the exact same issue. The terms that I'm identifying here, such as rioters, looters, arsonists, are as loaded, if not more loaded, than the term victim.
Well, that might be true. That might be true, but we're concerned about due process to the defendant, right? We're concerned about the defendant's rights. So the issue might be the same with victim versus arsonist. The problem is we're only really concerned about one person's rights at the moment, the person on trial, and what their interests are. So calling people victims prejudices the defendant. Calling the arsonists, they're not the defendant. So it probably doesn't prejudice the defendant. So it doesn't present the same problems from a due process standpoint.
First, a defendant generally gets to put on whatever defense they want, so a court should err on the side of allowing a defendant to do something and get more freedom than the prosecution. But second of all, Judge Schroeder did not rule that the defense could absolutely call the men rioters and looters. He ruled that if the defense could prove that the three men were rioting and looting, then they could use those terms during their closing argument. And the judge prohibited the defense from using those terms during their opening statement, very similar to the ruling he made about the word victim. Neither side could use those terms unless they proved their case. That takes us to incident number 3, where Judge Schroeder dressed down the prosecutor, saying, "Don't get brazen with me." Judge Schroeder was again accused of bias when he blew up at prosecutor Thomas Binger. First of all, yes, judges do yell at lawyers, and sometimes those lawyers deserve it. Some do it more frequently than others, and Kenosha lawyers say that Schroeder is definitely a yeller. Now second, the judge sent the jury out of the room before admonishing the prosecutor. And third, and most importantly, we should look to what caused Schroeder to blow his top. When Rittenhouse took to the stand to testify in his own defense, the prosecutor seemed to refer to Rittenhouse's prior silence about what happened. Quote, "Since August 25th, 2020, this is the first time that you have told your story." That's what the prosecutor asked on the stand. The defense immediately objected, and Schroeder sustained the objection, disallowing the question. And there's good reason for that. In criminal cases, the Fifth Amendment protects against self-incrimination, among other things. This means that a defendant's decision not to talk can't be used against them.
I'm confused. Are we getting a good legal video from Legal Eagle? Because so far this has been pretty good. It's actually been educational. Wow. I don't know. Maybe he looked at our prior criticism and took it to heart. I might have to amend the title of this video after the fact. But so far we're getting pretty good. If you had asked me as a betting man, I would have said, there's no way Legal Eagle's going to say, "Hey, why did the judge do that?" Right? Why did the judge say brazen? What was he upset about? But he did tell you. He did tell you exactly what the issue is. And then he's telling you why that's a problem. So far, I as always, as ever, I try to be fair. And I think this is proof, again, that I try to be fair. I hold no passion nor prejudice. When someone makes a good argument, I acknowledge they made a good argument. All right? And so far, he's making good educational content. So, I can praise and condemn with equal measure as the case may warrant. All right. Maybe we'll wind up condemning him later, but so far so good.
The judge sustained the objection because Binger's question was too close to the line. But then Binger basically asked the same question a different way. He referred to the many months of people talking about the case and said, quote, "After all of that now, you are telling us your side of the story, correct?" It seems that what Binger was getting at was that because Rittenhouse hadn't testified before and was now testifying after everyone else had taken the stand and after all of the evidence had come out, that Rittenhouse was now in a position where he could change his story and craft it to be consistent with everyone else's testimony. But of course,
that's what Binger tried to justify it after the fact. But the way the question was phrased was very poor to that end. Because the prosecution does have a right to note the defense, and the defendant had an opportunity to hear all the testimony and has the ability to conform their testimony. In a trial, it is very typical, in fact, typical to the point of unusual if it's not true, but it's very typical that all the witnesses are not in the room. None of the witnesses are in the room at the same time as the other. So it's more common by far that none of the witnesses are in the same room as the other. The idea, at least in part, being that, they can't hear each other's testimony. So, they don't necessarily know what they testified to. So we think that will be an additional benefit. Now, obviously, they might have talked beforehand, so it's not a guarantee, but, why give them one more thing, I guess, is the idea. So the maximum extent we can, we separate the witnesses so they can't talk with each other. But, of course, that doesn't apply to the defendant, because the defendant has the right to confront his accusers, remember? So the defendant is there through every single witness, unlike a typical witness. Expert witnesses can be there through every single witness. But the reason expert witnesses can be there is because they're not fact witnesses. They're testifying as to expert opinions. So their ability to hear facts doesn't prejudice their opinion, because they're not giving factual recitations. So there is an exception there for expert witnesses. But the defendant's there. So the prosecution does have the right to note that and say, yeah, you had an opportunity to conform, which Binger did later ask the question that way. The problem is the way he phrased this question seems to speak a little bit more, to my mind and the judge's mind, to his silence, not his ability to conform. So that was the problem. Binger's phrasing sucked.
A question can be two things at once, and if it's too prejudicial, even if there is some probative value to it, well, then the court can still disallow it, which the court specifically had done. Schroeder had disallowed it. So Judge Schroeder asked the jury be removed so that he could basically just yell at Binger.
You need to account for this. The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right. You're right on the borderline, and you may be over, but it better stop.
In other words, it doesn't matter whether you think Rittenhouse was guilty or not in the context of a criminal trial, his post-arrest silence couldn't be used against him. Binger said he understood, but then to add insult to injury, he then plunged into a series of questions about a matter the judge had already...
Oh my God. Legal Eagle is being a good educator. Legal Eagle is being a good educator. He's explaining it. He's providing facts. He's letting you hear the things. He's explaining why those things are important. Holy shit, dude. Legal Eagle is being a good educator. I'm not sure whether or not to praise him for this or condemn him for other things where he's not doing that, because obviously he's capable of it if he tries. But there is a good rule, there's a good maxim, which I am not a good adherent to, but I try. I do poorly on it, but I try. And the maxim is, you never punish someone when they're doing the right thing. You never punish someone when they're doing the right thing. And you might say to yourself, well, that's obvious. But here's an example, case in point, right? Because I could take the fact that he's saying the right thing now and use it to criticize things he's done in the past, right? Instead of praising what he's doing now. So I could use this opportunity to shit on him, and then I'd be punishing him for doing the right thing, right? So I should not do that, because you don't want to punish someone when they're doing the right thing, because you want them to do the right thing. So, I guess... Praise be, learned counsel, Legal Eagle, for your good legal education with good presentation of facts and laying out the story and not hiding the ball. Okay, all right, fine. That's where we're at.
Already previously ruled was off limits, a video where Rittenhouse fantasized about shooting alleged shoplifters. Which takes us to incident number 4. The judge ruled that the prosecution could not show a video showing Rittenhouse saying that he wished he could shoot 2 people leaving a CVS store. Now, the background is that before trial, the prosecution moved to introduce evidence of a video where Rittenhouse says he wished he could shoot 2 people who were suspected shoplifters. The prosecutor said the video was relevant to Rittenhouse's state of mind and motive. He said Rittenhouse was, quote, essentially a teenage vigilante involving himself in things that don't concern him. Now, the judge excluded the video on the grounds that the video wasn't made before the riots. It was recorded 2 weeks earlier. And the judge felt that in another video, which allegedly showed Rittenhouse assaulting a girl who was in a fight with her sister, was also not relevant to what Rittenhouse did on August 20th, 2020 in Kenosha. The video suggested Rittenhouse had a propensity for violence, but neither video had anything to do with the protest. Now, it's important to note that judges are arbiters and are supposed to protect the rights of a criminal defendant. And certainly these videos make Rittenhouse look bad, but we aren't supposed to convict people for looking bad. The judge was limiting the evidence so that the only evidence the jury heard had to do with what actually happened on August 20th when Rittenhouse encountered the 3 men. Now,
Yeah. Right. Correct. Amazing. Yes, that's right. What matters What matters is what happened at the time. Self-defense existed at the time in the face of imminent threats. So what happened 2 weeks later doesn't really speak to what happened in the moment, does it now? How can something 2 weeks later really speak to what happened in the moment of self-defense? Says Judge Schroeder. So the fact that he went to this bar and had a shirt that said free as F with people who were Proud Boys or whatever, makes him look bad, but legal's correct. We don't convict people merely for looking bad or having the wrong affiliations. Who are you and what have you done with legal?
Crim Law 101 is that you can't, or at least generally you can't, because there are always exceptions. You can't use propensity evidence to show someone committed a crime on a specific day. You can show that they committed the crime at issue, but you're not allowed to convict them because they had a certain propensity towards crime. Generally speaking, a criminal defendant can't be convicted just because they have a history of doing bad things. The state still has to prove that they committed the crimes they were charged with. And so when Judge Schroeder yelled, "Don't get brazen with me," it was the culmination of two mistakes by the prosecutor, referring to Rittenhouse's post-arrest silence after being told not to, and referring to the CVS videotape despite being told not to. Binger felt that the defense had opened the door and it was now okay to go into that subject area, but even if that were the case, you still need to get permission from the judge or face their wrath. And Binger still had a hard time letting it go. Quote, "This was the subject of emotion, I'm well aware of that," and the court left the door open. But Judge Schroeder screamed, "For me, not for you. You should have come and asked for reconsideration." All trial lawyers know that if you appear to disregard a judge's order, you're probably going to get it. And to the judge's credit, while we all got to see Schroeder lambaste the prosecutors on the live feed, the jury was sequestered away and would have been completely unaware, so it wouldn't have prejudiced the prosecution's case. That takes us to incident number 5. Judge Schroeder allowed Rittenhouse to...
Non-ironic round of applause. Jury wasn't there. He mentioned it earlier, and now he's re-mentioning it. He mentioned all the reasons, like 2 questions that referred to the defendant's right to remain silent, 1 question referring to evidence that was excluded. So three pretty brutal screw-ups right back to back. Fifth Amendment violation, evidentiary violation. And the judge got a little bit pissed because they all happened right next to each other. And so each time he asked the jury to exclude. And the third time, he's like, and they're saying, well, it kept the door open. And the judge is like, "Don't get brazen with me. Left it open for me, not for you," which is absolutely correct. You have to ask, So, and he knows the jury wasn't there, and wow. Okay. All right. Yeah, fine.
To pick his own jurors? Well, not exactly. Judge Schroeder had Rittenhouse blindly pick the 12 jurors who would be deciding his case out of a hat. It's weird, but in Wisconsin and other states, the courts regularly seat more jurors than necessary because at the end of trials, it's common for jurors to be stricken from the panel for various reasons. This could be for misconduct or a juror having a family emergency or just getting sick. In the Rittenhouse trial, 18 prospective jurors heard all the evidence. After closing arguments, the judge told Rittenhouse to randomly pick 6 numbers out of a tumbler. Those 6 numbers were stricken from the panel. The 12 who were left were his jury. Whittling down the jurors is not unusual. Picking them out of a hat is somewhat unusual. Judge Schroeder said he'd have defendants do the selection for years. He said that responding to critics, he started doing it after a case where there was only 1 prospective black juror. That person was eliminated from the jury when the clerk picked that juror's name out of the panel. That resulted in a black defendant being tried by an all-white jury as a result of one of the court administrators. Judge Schroeder felt that that was not ideal. He said, quote, "It was a bad optic, I thought. I think people feel better when they have control. So ever since that case, I have had an almost universal policy of having the defendant do the picks." When only one part of Judge Schroeder's explanation was cherry-picked and then circulated among social media, it looked terrible. But actually, it seems like his explanation makes perfect sense. While this process is a little bit theatrical, the reasons for doing so actually empower the defendant, and it's hard to imagine that there would be any prejudice to either the defense or the prosecution as a result of this particular foible. That takes us to incident number 6.
So he acknowledges He acknowledges that the process makes sense. And he even goes into a fact I didn't know. Legal Eagle just literally taught me something. I don't know how to respond to this. Legal Eagle just taught me something. This is a strange and confusing time for me. Hold on. Because I didn't know about this prior incident. I didn't know the reason that they drew him out of a hat for in this court. I just assumed that it was, you know, a Wisconsin thing or, you know, whatever. I didn't really think about it that hard. I didn't realize that it was a Judge Schroeder specific thing, and I didn't realize it was because of a prior case with where a clerk did the right thing, but it led to this weird optic. And so he's like, well, to avoid it, I'm going to do it so the defendant does it instead to avoid the problem. I just learned a thing from Legal Eagle. Hold me.
The judge disallowed zooming in on a video? Well, not exactly. Judge Schroeder was mocked for sustaining a defense objection to zooming in on video footage via an iPad. This was presented as either a nefarious plot between the defense lawyers and the judge, or as evidence that the judge was old and out of touch. Now, it's not that the judge said that they couldn't zoom in at all. The judge just ruled that the prosecution could zoom in on images as long as they had an expert testify as to how the pinch and zoom worked on an Apple device, to make sure that that process wasn't adulterating the evidence. Now, the prosecution couldn't produce an expert on short notice, so the jury wound up seeing the video on a Windows machine hooked up to a TV. Now, this was kind of a ticky-tacky objection by the defense, but in fairness, lawyers are required to authenticate an item of evidence, and this applies to every piece of evidence that's introduced, including government records, business records, photographs, video, audio, you name it. But look, the prosecution has the burden of proof, so it's on them to make sure that what they're doing, if they are changing the evidence in any way, isn't adulterating the underlying evidence. And of course, there was also
yeah, that's correct, Eagle. Right. The prosecution has the burden of proof. They're introducing the evidence. They're the one introducing it. And they can't provide an expert who can authenticate the evidence. So they can't meet their burden. So it was excluded. That's 100% right. Okay.
also an issue with drone footage where a file was smaller than it should have been. And that takes us to the next incident where the judge apparently asked the jury to applaud for a defense witness. Well, sort of. This one is interesting. On Veterans Day, Judge Schroeder decided to recognize anyone in the courtroom who had served in the armed forces. Quote, "I just want to observe that it's Veterans Day, and any veterans in the room, on the jury, or anywhere else?" When no one responded, the judge said, "Well, that's unusual not to have at least someone in here, but Dr. Black is what branch?" He was referring to the defense witness, John Black, who was about to take the stand. Black is a use of force expert who told the judge that he had served in the Army. The judge then said, "Okay, I think we can have a round of applause to the people who have served our country." The entire courtroom applauded, including members of the jury. This one was just sloppy and completely unnecessary. It seemed to have the unintended effect of bolstering the reputation of Dr. Black before he took the stand, who happened to be a defense witness. But it was just completely unnecessary to run that risk for, a little grandstanding in this particular case. And then
he humanizes legal has humanized the judge. I think the judge probably did make a mistake. It was a mistake. Probably the judge realized it was a mistake after the fact. He could have just said, "Let's give a round for the troops." Just in general, that would have been fine. But he probably made a mistake by asking for people in the audiences, because the even bigger mistake, and I don't know if the judge knew or not, but the bigger mistake would have been if one of the jurors, especially one of the jurors, was armed forces. That's the even bigger problem. Because now suddenly you're applauding this specific juror and highlighting them as a person of particular virtue. How do you think that might go in the jury deliberation room? So the judge kind of lucked out on that one. I mean, he didn't seem to know for sure. I mean, he specifically asked if there were any members of the jury. If one member of the jury had stood up, be like, "Yep, it's me. Let's applaud him." Man, that's got to be awkward as shit, and there's mistrial possibilities built into that big time. because we suddenly elevated a juror beyond of a particular importance, man. So we're looking at a mistrial in that situation. But Legal Eagle humanizes him. It's like, yeah, it was just a mistake. It just so happened that this was the only person then, and so it was a little weird because he was just about to testify. So, not really well considered, well thought through. Judge kind of made a mistake. Glad it didn't burn him more than it did. But he was just trying to say nice things about the troops. Okay, yeah,
There were accusations that Judge Schroeder was just unusually chummy with Rittenhouse and wanted to see him acquitted. For example, there's a picture of the judge and Rittenhouse being very close together as they're watching a video. But equally likely is that Schroeder was just a relatively pro-defendant judge. And of course, there's a wide disparity between criminal defendants who are remanded to custody and those who are out on their own recognizance. Rittenhouse was able to attend, not in shackles, not going back to prison, and in a suit. We don't want to make things too easy on the prosecutor, and maybe the answer here is that criminal defendants more often should get the benefit of the doubt like Rittenhouse did. But more pragmatically, if a judge doesn't err on the side of the defense, they are likely to see an appeal, and no trial judge wants to A, get reversed by the Court of Appeals, and B, have to retry a defendant. And that's one reason why they might err on the side of disallowing evidence that might otherwise come in to make sure that there aren't other constitutional violations. And for better...
So, yeah, correct. The defendant has due process rights, and so if we're going to err, it's probably better, all things being equal, to err on the side of the defendant. Because if we don't, we risk upsetting the defendant's substantive due process concerns. So this is probably good. And Legal Eagle says not only is it good, we probably should do more of it.
Or worse, Schroeder was clearly paying attention to how the trial was covered. Quote, "When I talked about problems with the media when this trial started, we're there in part, not fully, but in part, because of grossly irresponsible handling of what comes out of this trial. I will tell you this, I'm going to think long and hard about live television of a trial again next time. I don't know, I've always been a firm believer in it because I think the people should be able to see what's going on, but what I see, what's being done, is really quite frightening. Frightening, that's the right word for it." Now, I can't imagine how he possibly got that impression, which takes us to the final incidents. Schroeder had a racist cell phone ringtone. Come on, people!
Was that sarcastic? I mean, if it was sarcastic, I didn't quite pick it. Did he literally mean I can't understand how he come to depression, or was that intended as a sarcastic comment? I honest to God, I'm not sure. And I can't believe this, but I'm giving Legal Eagle the benefit of the doubt. I can't believe it, but I'm doing it. I'm giving Legal Eagle the benefit of the doubt. I'm going to assume that it was meant as a sarcastic comment. I can't imagine why that would be the case, even though we all know exactly why it would be the case. So I'm going to be charitable, and I'm going to interpret it as a sarcastic remark that just didn't quite come off that way. I'm giving the benefit of the doubt to the Legal Eagle, man. It's a banner day over here in Uncivil Law.
A cell phone ringtone? Really? Come on. You're better than this. But also, Judge Schroeder, dude, turn your cell phone off in court. That is rule number 1. Now, there is no doubt that Schroeder is a crotchety old man, but maybe that's just because his cell phone plan is too expensive. He's getting calls all the time, even when he's in court. He could have saved a ton of money by switching to today's sponsor, Ting Mobile. In fact, I personally switched to Ting Mobile and saved...
Well, my friends, it's a Thanksgiving miracle. It's a Thanksgiving miracle. This Legal Eagle video has the seal of approval from Uncivil Law. That's where we're at. That's where we're at. This was a good video. This was a good video. It was good education. It explained the things. It provided the underlying facts for the things. It provided the video for the things. It went over the due process concerns. It was a fair, accurate, reasonable, thoughtful, good educational video. That isn't to say that it's perfect, but you know, it's really good. I might have done it differently. I might have presented some things differently, but you know what? You know, if the man gets it right, I, on Uncivil Law, do my absolute best to always just call it like I see it. And man, Legal got it right. That's where we're sitting on this one. It's a Thanksgiving miracle, man. We're definitely going to have to change the title. In fact, I'm going to change the title right now. Excuse me. Let's just change the video title right now. Legal, let's see. Talk amongst yourselves. Okay. The video title and description have now been changed. Video title and description have now been changed. Okay. Let's read some super chats, I guess. $5 from Living the Dream. Thanks, Uncivil. You're doing civil service. Entertaining people with the law. Thanks. $5 from Retroactive Redhead. I don't know what you paid for this masterpiece of a thumbnail, but whatever the investment was, it was worth it. This thumbnail was lovingly produced by my moderator, Stephanie, who has much better aesthetic eye than I do. So thank you, Stephanie, for this wonderful thumbnail. It was really good, and I appreciate all your support for the channel and your support of me personally. Super chat, $5. Happy Thanksgiving, my dude, from Patient Zero. Happy Thanksgiving to you, Patient Zero. $9.89 from Mithrin Emrys. He said following it on social media, not watching the trial, fine. The judge has a standing rule not to call them victims. Yes, the defense did not have to ask. I'm pretty sure they still asked. $5 from Shut Up I Can Cook. Brazen, lol. Enjoy everyone. Sending love to all. $2 from Pies God. Quick, someone make sure the pigs aren't flying. $5 from Jan Campbell. Thank you for your steadfastness through Rittenhouse and Arbery. Very consistent presence always with an arch take. $5 from Jacob. Who is this person? This is not Legal Eagle. Is it his twin brother or is he replaced by the pod people? I don't know, man. $2 from Shut Up I Can Cook. Watching Silverado. Thanks for the stream. $5 from James Knoll. Happy Thanksgiving, sir. Love your content. Blessed Thanksgiving to everyone in the chat. $5 from DX61905. I watched one of this guy's videos once and always remembered him as an off-the-rack version of Donald Trump Jr. $10 from Mandrake. Okay, now I know the aliens have abducted the man in the suit. This is nuts. Awesome presentation. I just can't believe it. $5 from The Real Honser. Any way to send this guy to the front line? $5 from The Denialist. Legal Eagle was somewhat good in this video, so I'm okay with giving him the benefit of the doubt. $5 from Scott Gimble. Thank you for your obviously fair content. I think this might go to prove what I've always said, that I'm not biased. And this is one of the reasons I get accused, or this is one of the reasons I get a bit salty This is one of the reasons I get a bit salty when people accuse me of bias. I am not biased. I am not biased. I analyze the facts, and wherever the facts lead, the facts lead. And where the facts lead to the conclusion that Legal Eagle is doing a good job as a legal educator, that's what I say. I don't think I will have to convince anyone in the chat that, as a general proposition, I have a somewhat negative opinion of Legal Eagle. But my somewhat negative opinion of Legal Eagle did not preclude me from reaching the right facts, because I try very, very hard to be good. So, you know. $5 from Nico. You should rename this stream to Uncivil Law Gets Something by the Mighty Legal Eagle Live. By the way, how drunk are you, good sir? I'm not very drunk at all. I've had about half a bottle of wine. Super chat from $4.99 from Mithrin Emrys. Holy cow, Legal Eagle got one right. Good on him, one more, and he matches a broken clock. $5 from Jan Campbell. Are you up for reviewing Andrew Bianco's Arbiters case take on Tim Pool last night? At odds with you, Viva Nate. I've watched it. I don't think I watched all of it because I kept getting interrupted, but I think I watched the vast majority of the segment where they talked about it. I'm looking at having Andrew Bianco on next week where we can talk about it more in full. But actually, as a matter of just reading the words on the page, I agree with Andrew Bianco. My understanding is that there's case law, though, that goes the other way. So if I were reading the statute, and I've said this before, so this is not a change of position. But if I was reading the statute in a void, I would agree with the way Andrew Bianco's reading it. That it doesn't really make sense to read them jointly. But there might be case law that speaks to this proposition. Also, I'd have to go reread the jury instructions to see how they were actually charged. So to see whether or not how the jury charge was. But I agree with Andrew Bianco that if I were reading the statute without the case law, I'd come to the same conclusion. So then the question becomes, okay, is the case, there's two questions then. There's two questions then for me and Andrew Bianco to solve. First question, is there case law that compels this result? And second question is, how is the jury actually charged in the actual instructions? Because whatever debates they were having among the lawyers, in the courtroom, the jury didn't hear that. What they have is the jury instructions. So the question is, are the jury instructions wrong? How are they actually charged? And we'd have to look at that. So, but Andrew Bianco's right. Andrew Bianco's right in as much as what he said, I think. But there's other things that might compel the opposite conclusion. $5 chat from Raven K. Where can I get a hat like that? That thing rocks. This particular hat was made for me custom by hand by a hatter. So, find out who makes custom hats, I suppose, near you. This one was made by Texas Hatters in Lockhart, Texas, if you're into that. And $5 chat from Nuvi. Thank you. $20 from DIL IGF. What would it take to get a governor's pardon in Texas? If you don't know, do you know who would? I don't know the answer. I don't know the answer. I would have to Branca. I said Bianca. I'm sorry. It's Branca. I'm sorry. Branca, not Bianca. I'm sorry. I don't know. What I would do is I'd call criminal defense attorneys and ask them. Just call criminal defense attorneys in near Austin, because in the state capital they're most likely to know. So call some criminal defense attorneys and see if they can point you in the right direction. But thank you for the super chat. Joe's Med said, I think a lot of his left-wing audience saw the other side of the story for the first time with this video. It's one of the few Legal Eagle videos about a controversial topic I actually liked. Well, he made a good video about why the judge's ruling was good. He provided the background. I wish he would have done that with other things. Neo Zeus said, but Legal Eagle hurt my feelings. Yeah, facts don't care about your feelings though. Is Legal Eagle starting to believe? Is this a red pill moment for Legal Eagle? I have my doubts, man, but maybe it's a step closer. Next, you will have Legal Eagle on your show. At this point, man, we'll be BFFs. I won't know what happened in between. Psychotic Doll says, shit, I'm creeped out with this. You being nice to Legal Eagle. Can I sue for my pain and suffering? I'm joking mostly, but still weirdly creeped out by Legal Eagle having a decent video. I know, man. I mean, let's get more like that. We are through the looking gas. Aislick says, are you smelling toast? Because it looks like you're having an Archer-type aneurysm. Erica Joe says, be just as forceful with the language as when you thought he was going to act like a fool. I thought I was pretty forceful with the language. I thought I was pretty clear and forceful. Brendan says, can defendants be expected to know the case law? No, of course not. No, of course not. Nor do they need to. Okay, well. $5 chat from Pancho Villa. In the Arbery case, why was the driver convicted of murder instead of as an accessory? I went through that video and I went through it in detail. I would encourage you to go watch my video on the subject because I go through it in some detail to explain it. So hopefully the video I did very recently will explain your questions. $5 from Afro Fry Cook. Could you do a video where you give an example of going through case law for a statute for us laymen? I could try. I could try to put something together. No promises. $5 from Starscream 1540. Are fish tangible objects? Yes. They are an object and they are tangible. Yeah. Can you do a breakdown of Yates versus United States? I'll look into it. Well, everyone, I'm going to sign off. Happy Thanksgiving. And happy Thanksgiving to Legal Eagle for this legal educational content. Please remember to check me out on Locals. It's uncivillaw.locals.com. Please remember to subscribe and hit the like button because, they like the YouTube engagement stuff, and hit the notification bell and all that good stuff. So, all right, I'm going to sign off. Have a happy Thanksgiving. Until later, my friends, cheers and goodbye.